Good morning, all. This hearing is in the matter of CFI 045-2025 and is being held by way of video conferencing before Her Excellency Justice Sapna Jhangiani, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course of or after this hearing will be issued by the Registry in Dubai on the judge's instructions. The claimant is a litigant in person and has not appeared in today's hearing. The defendants are represented by BSA Ahmad bin Hezeem and Associates. Lead counsel is Mr. James Leabeater, KC. Thank you, Your Honour.
Thank you. May I just check that I am pronouncing your name correctly? Is it Leabeater?
That's correct, yes, Your Honour, thank you.
Wonderful. So, Mr. Leabeater, it's your application. Please feel free to proceed, but I did have a couple of questions, and I think that it might be quite useful if we get them out of the way early, because I think they may impact how you proceed.
Okay.
So, they really relate to the basis of the second defendant's application. So if we look at the bundle, and I'm on page 41 of the bundle, sorry, page 40 of the bundle, if you have that to hand.
Yes.
Yes. And so if you look at the description of the second defendant's application, the description is that the DIFC courts lack jurisdiction to hear this matter due to the arbitration clause in the escrow agreement and the mandatory provisions of the DIFC arbitration law. So essentially the same grounds as the first defendant's application. But then if we scroll down to page 41, we see that it's an application for the claim against second defendant to be set aside or struck out for the reasons set out on page 41, which is essentially how the application has been argued and the basis of the second defendant's evidence. So I wanted to understand the nature of the second defendant's application, and a related question is that if we look at the claim against both defendants, if the court considers that because of the arbitration clause in the escrow agreement, the entire claim should be stayed in favour of arbitration, then it would be for any arbitration tribunal, if and when an arbitration were pursued against the defendants. Maybe it wouldn't be pursued against both, but let's assume it will be pursued against both. It will be for the tribunal to decide its jurisdiction. So I'm just trying to think of exactly what the court has to decide and what order. I don't want to be deciding things that are not necessary for the court to decide. And it strikes me that it's important for me to know the basis of the application and really what the defendant's submissions are on the particular issue that I've just raised.
Yes, that's very helpful, if I may say so. So if I can try to deal with both of those issues in this way, the application is put in the name of the second defendant for a strikeout and set aside for the reasons you've given on set out on page 41 of the bundle. That there's no reasonable cause of action disclosed. The application notice is headed in the same way as the first application, as you've also noted. Now, that doesn't seem to be how it's put in the claim, but it may be that one analysis is that the claim is essentially on the escrow agreement, and in relation to the claim on the escrow agreement, the claimant would like to make some allegation against the second defendant personally. Now, if that were the case, and I don't know if it is, but if that were the case, then as Your Honour has intimated, it seems likely that the proper jurisdiction for that would be the arbitration and not proceedings. Because if some claim were to be made which was founded upon the escrow agreement, one would think that the arbitration clause would be the appropriate form in which that claim should be decided. And it would be, as Your Honour indicated, for the arbitration tribunal to determine whether it had jurisdiction over a claim made by the second defendant arising out of the escrow agreement. So if that is what the claimant would like to argue, then yes, I accept that the appropriate order should be a stay and not a strikeout.
And I suppose that leads to the issue of, well, what is the claimant's case on this? Because if you look at the claim form, it seems to be clearly asserted that the basis of jurisdiction is the clause in the escrow agreement. Now, I'm aware of what the escrow agreement actually says, but let's leave that aside for the moment. But that would suggest that it's the escrow agreement that is founding jurisdiction against both defendants, and that seems to be what's set out in the claim form. All the claims that are alleged relate to the escrow agreement, and it's not 100% clear, but duties that seem to arise under the escrow agreement. But if I look at one of the replies to the defendant's applications, it is suggested that the second defendant cannot rely on clause 15 because the second defendant is not a party to the escrow agreement. So ultimately we're seeing the exact opposite argued, and I accept that that can be confusing, and the court will have to will have to take a view on exactly what the claimant's position is and what they were able to argue based on what was in the claim form. But there is this issue that what some of the allegations that have been raised against the defendants are that there have been regulatory breaches. There's an allegation that it's not permitted under DIFC law to be an escrow agent. And I suppose the question is, insofar as one can make out causes of action that are not related to the escrow agreement, and I think the suggestion is that there are some causes of action that have as their basis regulatory breaches, and it's suggested that those cannot fall under the arbitration agreement. And I don't think there's a distinction between the case against the first defendant or the second defendant. I suppose I'm trying to think of, it's a bit hard to do this without fully understanding what those causes of action are supposed to be, but I'm just trying to understand what would the defendant's position be in response to this argument that there are regulatory infractions giving rise to causes of action that fall outside the escrow agreement in relation to the defendants. And again, you don't have to actually respond to this now, because I recognise that I would like you to be able to present your case in the way that you see fit. But these are issues that are concerning me, so I thought it's good to highlight them to you, so you can help the court navigate what it has to decide.
I'm grateful. Well, perhaps I will try to deal with that question in the course of my submissions as I go through. Your Honour, if I may then, I start by just putting on the record that in circumstances where we now understand the claim not to be represented and not in fact to be here, I understand that my duty is to draw your attention to any matters, any decisions or provisions which may be adverse to the interests of my client, and I will endeavour to do that.
Thank you.
This is a strange case, as Your Honour will have seen, both in relation to the way that the claim has been presented and also some of the substance of the complaints that have been made. You will have seen in my skeleton argument that we have great concerns about the way in which the claim form was issued and the way in which evidence has been adduced before the court. And skeleton argument was purposefully drafted on the basis that there were reasonable grounds to query whether the claim had been properly issued and whether those purporting to represent the claimants in fact did so. but in light of the claimant's skeleton argument, those concerns, I think, have been elevated because there haven't been any answers provided to any of those points. And I think they are three issues, each of which is quite serious. The first is that the claim form was issued and the statement of truth signed by an individual called Jhangiani of the United Arab Law League Enforcement and Legal Consultants, FZC LLC. Now, that entity doesn't appear to be on the DIFC register of practitioners, and it's not clear the extent to which it exists or has authorized lawyers, and no information has been provided in response to that in the claimant's skeleton argument. Although the claimant's skeleton argument is said to have been drafted with assistance from United Arab Law Enforcement League and Legal Consultants LLC. So that is a problem, and it hasn't been answered. And of course, the authority of the person who in fact issued the claim form to do so and to represent the claimant is of great importance in relation to the court procedures. So that is a significant point. That's point number one.
Just to raise one point at this stage, my understanding is that the claimant has simply been considered to be, and I've not had an opportunity to look into the whole history of this, but he's simply on the record as a litigant in person and has been since the claim was started.
Right.
Because of course, as you raise, it's an issue if a practitioner on the record for a claim is not registered before the court, of course. But I understand that formally he is a litigant in person for the purposes of this claim.
Yes, understood. And no doubt that was the appropriate way for the court to proceed in circumstances where it couldn't ascertain that the legal representative was on the register. But nevertheless, I do make the point that the claim form itself has a statement of truth signed by Mr. Pardev, and if he was not authorized to do that because he was not an authorized legal representative, then it follows that the claim form has not been properly supported by a statement of truth, which is an important issue, and it's important in this context where as I'll come on to in a moment, the facts alleged are extremely vague and rather murky, because I don't know whether it's going to be said at some later stage by the claimant or somebody else that in fact the matters set out in this claim form were not properly authorized, or in fact were not properly put forward on behalf of the claimant. We simply don't know what will happen. So that's point number one. Point number two is that the evidence in response to our applications came in the form of witness statements from a Mr. Robert Kravitz, who says in his witness statements that he's an attorney and a managing partner in the firm of Morgan Kravitz Klein, PA Morgan Kravitz Klein. Now, again, as we set out in the skeleton argument, we're not sure either that firm or that individual exists. And there's been no response to that in the claimant's skeleton argument. And that is again extremely troubling, because as things stand, we have no assurance that the evidence that has purportedly been filed on behalf of the claimant has been filed on behalf of the claimant, and it's not been signed but on behalf of the claimant. So that is extremely mysterious, and it is only made worse by the fact that, having been given the opportunity to respond to it, the claimant has not done so. So that's point number two. And then point number three, as you will have seen from my skeleton argument, the claim form is littered with simple mistakes in relation to the law, mistakes which can't properly be made in relation to the existence of legal instruments or legal authorities, and for example, in the relation to the case of the Fiona Trust, misrepresenting the very substance of the case. Now, of course, one is aware in jurisdictions all around the world that cases, non-existent cases and authorities are being cited which have been generated. I don't like the word hallucinated, but have been generated by AI, and I have no idea whether that is the case here. But it's certainly not a practice which the court should accept, in my humble submission, and it is not a practice which any practicing lawyer should permit to happen either. So that is point number 3. Now, all of that is in a way background, Your Honour, but it's important background because it casts doubt my submission on the bona fides of this case. Now, moving then to the substance of the case, all that we can understand from the claim form is that it relates to the escrow agreement. Now, there's no doubt that the escrow agreement exists and has been signed. The claimant's skeleton argument seeks to make various points about whether it has in fact been signed by individuals or whether you can make out the signatures and whether, I suppose, the parties to it consented to it. But that is an inherently contradictory position for the claimant to take, bearing in mind that the claim appears to be advanced on the escrow agreement and seeking to rely upon its provisions and make a complaint that it hasn't been complied with. So all I think that we can be certain of in relation to this claim is that it arises out of the escrow agreement to which the claimant and the first defendant are both parties. As you said, the claim form said that the escrow agreement contained an opt-in jurisdiction clause in favour of the DIFC court. Now that was a fabrication. It doesn't, and it is inexplicable in truth as to how that assertion could have been made, not just by a lawyer but by anybody, because it in fact contains an arbitration clause, as you've seen. As for the substance of the complaints made about the escrow agreement, they are extremely difficult to understand. The only clear assertion is in paragraph 11 of the claim form, which is on page 7, which is the defendants continue to illegally retain funds, monies, documents and authorities duly owed or belonging to the claimant, which appears to relate to the escrow agreement. Now, my instructions are that that is not correct in that the sums have been properly paid out of this escrow agreement, but that is not an issue for today. You can't decide that. That is an issue which will be determined, if at all, in my submission by the arbitrators. And that is one of the reasons why we've tried not to engage on the facts of this dispute. But if it is right that that is the substance of the dispute about whether sums have been properly paid out or should have been paid out under the escrow agreement, that is fair and square within the arbitration clause. And if and insofar as there is an allegation made by the second defendant in relation to that, well, I do say that there are no facts which would be capable of giving rise to a personal liability on his part. But I also take Your Honour's point that probably should be a matter for the arbitrators rather than this court, if in truth the substance of the point is that sums have been wrongly withheld by the defendants under the escrow agreement. So that claim in my submission is fair and square within the arbitration clause, and Your Honour will be aware, but more aware than me, I'm sure, of the lack of merit in the claimant's submissions that if there are allegations of fraud or anything, or dishonesty or anything of that sort, then that would derogate from the efficacy of the arbitration clause. Of course, it wouldn't. The arbitration clause is a separate agreement, and arbitrators are regularly called upon to determine issues of fraud relating to causes of action on contracts containing the arbitration clause, and indeed fraud going to the root of the contract. That's the very basis of the Fiona Trust decision. Now, there are various other causes of action said to arise in the claim form, but they are extremely difficult to understand. I sought to go through them in my skeleton argument, pointing out that really the legal causes of action said to arise are simply not capable of being understood. So if we look at the claim form,
can you remind me of the page number, please?
I'm so
I think
sorry.
it must be right at the beginning.
Yes, it's page 7.
Yes.
So paragraphs 8 to 11, we've already touched upon. They are essentially apparently complaints about the escrow account and various allegations made about failures to respond and the illegal retention of monies. Now, because I should say this because it's a matter of public records, the defendants obviously dispute that. They have acted precisely in accordance with the instructions they've given, but that is not a matter for this court to determine today. Now, we then, paragraph 12 seems to be to a similar intent, in that it refers to a legal notice dated March the 12th asking for information and so forth. Again, that seems to arise out of the escrow agreement and therefore would fall under the arbitration clause. And then paragraph 13 seems to be an introductory paragraph to the remaining provisions. Now, paragraph 14 of the claim form is a mistaken reference to some allegation about misrepresentation. Now, leaving aside the mistake as to what the actual provision of law is, a claim in relation to misrepresentation would, of course, be caught within a standard arbitration clause, and that's precisely what this is. So that, in my submission, is certainly caught by the arbitration clause. Paragraph 16 says there was some admission about receiving funds on behalf of the claimant and an implicit agreement to undertake certain acts or requirements, and there is a misrepresentation. Now, obviously, I don't understand paragraph 16 because it's incomprehensible, but it does appear to be some sort of allegation of misrepresentation which would fall within the arbitration clause. Now, paragraphs 17 and 18 appear to relate to some form of allegation of a breach of a legal right causing loss. But again, paragraph 18, insofar as it's comprehensible at all, seems to indicate that is alleged to be a breach of the escrow account. So they say, in the defendant's communication with the claimant, the defendants implicitly confirm their acknowledgement to provide escrow agent services in accordance with DIFC law. It is abundantly clear the defendants had no intention to complete their obligations, thus denying the claimant of his legal rights. So it is an incomprehensible allegation, but it does appear to arise out of the escrow agreement. Paragraph 19 is a provision which doesn't appear to have any legal grounds, but again relates to an allegation of loss caused by breach, presumably of the escrow agreement. And paragraph 21, as you will have seen from my skeleton argument, is a completely made up provision, which doesn't exist under the federal law. It appears to be a claim in tort, but it in fact refers to restitution integrum, so it can't really be a claim in tort. So that is pretty incomprehensible. All the conclusion I draw from that is that it's probably something to do with the escrow agreement. So that's a slightly long-winded way of going through this document, which perhaps doesn't deserve the time it's being given. But the summary of the position is that the claim form itself appears to relate to the escrow agreement and therefore should be referred to arbitration.
Right. And in relation to paragraph 21, I take on board your point that it is a fictitious provision. But if there were a claim in tort, and again, I appreciate that it's difficult to discern that from the claim form, but would a claim in tort arising from the escrow agreement or related to the escrow agreement on the defendant's position, would that be caught by the arbitration clause?
Yes, it would, Your Honour. Yes. Again, as Your Honour will no doubt be aware, tortious claims in relation to contracts containing arbitration clauses are routinely determined in arbitrations. So the claim form itself does not raise any issue which even arguably could be outside the arbitration clause in my submission, and in a way that is the answer to this matter. I don't resile from the application in the name of the second defendant that in truth, insofar as this is a claim which is not based upon the escrow agreement, it has no reasonable cause of action. But if, having listened to Your Honour's question at the beginning, if the correct position is probably that if and insofar as the claimant thinks that he has a claim in relation to the escrow agreement against the second defendant, that should be made in the arbitration, and therefore the appropriate remedy or the appropriate order, I beg your pardon, is a stay to arbitration, that is. Now, turning then to the skeleton argument on page 330 of the bundle. As I said, paragraphs 2A, 2B, and 2B, and 2C and 2D seek to describe the paragraphs in my skeleton argument, querying the authority of those purportedly acting for the claimant to act for the claimant. They say that they are irrelevant and should be ignored by the court, but you have my submissions on that. They are important, and it is extremely concerning they haven't been properly answered. If we turn to the substance of the skeleton argument, such as it is, we see the chronology and background starts at paragraph 4. Paragraph 4 refers to the escrow agreement, and it makes the point about the signature, and says that the only signature which can be attributed is that of the claimant, Mr. Gheorghe, and complains that the other ones are not comprehensible. Well, none of that goes anywhere, of course, because the claimant relies upon the escrow agreement and he appears to accept that he signed it, and therefore the arbitration clause is binding upon him. Paragraph 6 complains that the settlement agreement was not has not been put before the court, but that doesn't go anywhere because that's not what he's suing on. And of course, my clients weren't a party to that settlement agreement. The claimant himself was a party to the settlement agreement and therefore no doubt should have his own copy. Paragraph 7 says the respondent repeatedly asked the first defendant for an account of receipts and disbursements and for the return of his funds. The first defendant failed to provide a coherent accounting and invoked a settlement agreement, yet failed to disclose it. Now, I don't understand that paragraph because it doesn't seem to relate to the facts set out in his claim form, and I can't understand, or I can't work out the references which are said to support to it. But in any event, it merely goes back to the same point about if this is in substance a complaint about the operation of the escrow agreement, then it belongs in arbitration. Now, paragraph 8 picks up one of the points Your Honour raised. It says, public registry material indicates that the first defendant is a DIFC registered LLP law firm. Extracts in the DFCA, DIFCF registries do not list escrow or client money service permissions for the first defendant. No evidence of a segregated escrow facility. Record asserts that money were handled through a non-escrow bundle account. I don't understand, again, any of the underlying facts in that paragraph. The BSA is a law firm within the DIFC, properly regulated, and of course it holds client money, and it is routine, at least in my experience, what that's worth for solicitors to act as escrow agents. So I don't understand the substance of that complaint. And then paragraph 9 says Mr. Holer, the second defendant, is not named as a party to the escrow agreement. Correct. His reliance on clause 15 is therefore in principle unavailable. Moreover, there's an issue raised to his capacity or authority consistent with regulatory and professional rules, including court practitioner registration. Again, there seems to be a jumble of words which doesn't really mean anything. It is right that he's not a party to the escrow agreement, but if insofar as they are making complaints about the operation of the escrow agreement, that is a matter for the arbitrators. Now we then go on to what is said to be the legal framework. I don't think we need to look at paragraphs 10 or 11. Paragraph 12 says regulatory overlay, DIFC regime and DFSA rulebooks, including client money protections, constrain what law firms may do. If a purported escrow service falls outside permissions, the agreement may be unenforceable as a matter of public policy and professional regulation. Now, no authority is cited for that provision, and it seems a little bit odd. Illegality, of course, can be used as a grounds for the courts not to enforce a contract if it is illegal in the place where performance is called for. That can't conceivably be suggested to be the case here. It's an unrealistic submission. But even if there were any substance to it, that issue of illegality being a reason not to enforce the contract would be firmly within the arbitrator's jurisdiction. And again, one sees time and time again arguments of that sort being brought before arbitrators. Allegations, usually on the part of the paying party, that the arbitrators should not enforce a contract because of illegality in some respect. That is, in my respectful submission, within the provisions of the arbitration clause. And that may be, at least in part, the answer to the third question you asked me at the beginning of the submissions. And then paragraph 13 says court supervisory jurisdiction where fiduciary duties over client monies, accounting and potential breaches by a regulated firm are an issue. The court may refuse a stay and retain control, including an order to account and restitution. Well, that is wrong as a matter of law. That is not a ground for refusing a stay to arbitration. Allegations of breach of fiduciary duties, of course, are routinely referred to arbitration. So then we turn on, and I'm sorry if this is taking too long, but it may be of assistance to go through it.
We have plenty of time, Mr. Leadbeater.
We then go into what is described as section E, submissions. The first point is no proven binding arbitration agreement. Well, you have my submission on that. The claim is based upon the escrow agreement, and the claimant accepts he signed it. So he must accept that there is an arbitration clause. Paragraph 15 refers to the fact that the second defendant is a non-party, and we have my submissions on that. Paragraph 16 says, even applying separability, a challenge based on lack of authority stroke forgery or absence of assent impeaches the arbitration clause itself. The burden has not been discharged. Well, again, that's wrong as a matter of law. Doesn't mean that the arbitrators don't have jurisdiction to determine the issue. Although it may be that an award on an arbitration clause which has not been authorised could also give rise to arguments at the enforcement stage. But that is not a grounds for refusing to decline the reference to arbitration at this stage for a stay. Paragraph 17 says the respondent's case is that the first defendant, a DIFC law firm, provided an escrow service which, outside its regulatory permissions, handling client monies through a non-escrow business account. If established at trial, the transaction would be tainted by illegality and professional regulatory contravention. The court should not enforce an arbitration clause to shield such conduct. The clause is null, void, or inoperative in the circumstances. Again, you have my submission on that point. It's wrong as a matter of law. Even if all of that were correct, which it's not, that would be within the arbitration clause. The illegality of the services offered would be an issue for the tribunal to consider as to whether that would be a reason not to enforce the agreement, although of course, given that the substance of the claimant's claim seems to be that it wants the escrow agreement to be enforced, it's not clear how that fits in with the rest of his case. Paragraph 18 says, preconditions and inoperability. If clause 15 envisages prior amicable steps, the uncontroverted correspondence shows repeated requests for accounting and return of funds were met with silence or deflection. A party cannot ignore preconditions and then invoke the clause as a sword. On these facts, it is inoperative. I don't understand that provision. We're not using the arbitration as a clause, as a sword. We're simply saying that if there is a dispute, it has to be referred to to the arbitrators. The clause itself on page 26, Your Honour, that does have a provision saying the parties shall use their best endeavours to settle such dispute or difference, and if the parties cannot resolve any dispute between them, any party may refer such dispute to arbitration in accordance with the arbitration rules of the DIFC/LCIA arbitration centre. Now, under arbitration laws that currently stands, an argument about whether the parties should have sought to resolve their dispute through discussions would be a matter of admissibility for the tribunal, not a matter going to their jurisdiction. Even under the old approach, where such clauses were more routinely regarded as going to jurisdiction, this sort of clause would lack the precision that would be required to give rise to any sort of argument that it was ineffective until the dispute resolution procedures had been carried out. So, although there are no facts alleged which would be capable of giving rise to lack of jurisdiction on the part of the tribunal, in this case, that would just go to admissibility.
I suppose even if it were a matter of jurisdiction, would that operate against a stay, or would it be a matter going to the tribunal for them to decide the issue of jurisdiction, admissibility, or whatever it is?
No, Your Honour, of course, is quite right. It wouldn't stop the stay being the appropriate step for the court. As Your Honour said, it would be a matter for the tribunal to decide whether they had jurisdiction or whether the party should first go away and carry out some steps. So then we're on to back to page 338 or 339 with the skeleton argument, paragraph 19. It says incapability. The clause refers to DIFC LCIA. Post decree 34, administration may be possible via DIAC, where formation is proven, but here the point is not institutional naming. It is that formation, authority, and lawful scope have not been established. So, as Your Honour is probably aware, decree number 34, which I referred to in my skeleton argument, is the decree which abolished the DIFC LCIA and replaced it with DIAC, which has been held to be enforceable under the DIFC law. So arbitration clauses are to be read, DIFC LCIA arbitration clauses are to be read as referring to DIAC, as indeed the claimant seems to accept in this provision. And the only point I think he's making is there's a dispute about formation, authority, or local scope, but that would be a matter for the arbitrators. And again, we go back to the original point. His claim is based upon the escrow agreement, so how he can say it's not a binding agreement is impossible to see. We then turn on to section E3, top of page 340 of the bundle, which is headed Scope and Public Policy, Fiduciary / Client Money Supervisory Jurisdiction. Paragraph 20 says the pleaded claims include breach of fiduciary duty, accounting for client money, misrepresentation, conversion, restitution, breach of professional obligations. Those matters arise within the DIFC and concern the handling of client assets by a DIFC law firm. The DIFC court is the appropriate form to supervise and, if necessary, to order immediate accounting and restitution. Any arbitration clause, if proved, should not be used to stymie supervisory relief in the public interest. Now again, all those matters, if they were set out in the claim form, and some of them aren't, but if they were, there would be matters within the arbitration clause. Fiduciary duty, accounting for client money, misrepresentation, conversion, restitution, and breach of professional obligations, they would all, with my respectful submission, be within the arbitration clause. Yes, the proposition, if it is such that an arbitration clause cannot be used to stymie supervisory relief in the public interest, is erroneous. An arbitration clause can govern the relationship between two parties. If there were some separate issue about professional conduct in relation to a regulated authority, then of course that would be a different issue, and that would also be a different form of proceedings. That's not what has been alleged here.
It would be regulatory proceedings, and presumably the regulatory body would be the body to receive such complaint.
Yeah, exactly. If there was a complaint, if there's a complaint about a regulated legal practitioner in the DIFC, a complaint is made, and I'm sorry I forgot the name of it, but there is a body, because I've come across it before, that regulates legal practitioners within the DIFC. And if the client's complaint is thought to be reasonably arguable, then it is put to the professional and the regulatory procedure commences. But that wouldn't be a procedure to be commenced by the issue of a claim form in the DIFC court. Then paragraph 21 says, in any event, the applicant's refusal to disclose even the supposed settlement agreement and a coherent account militates against a stay. The court should direct production and maintain control. Well, that's wrong as a matter of law. I mean, even if any of that was correct, which is not, that would all be within the arbitration clause. And then we go on to paragraph section E4, relating to decree 34. It says doesn't cure formation stroke pathology, and it says makes the same point again we've already dealt with. It doesn't. It presupposes, they say, a valid arbitration agreement. It doesn't cure missing annexures, illegible and unidentified signatories, non-party reliance or illegality, rendering the clause void or inoperative. Well, all of that is wrong. All of those issues would be within the arbitration clause and should be referred to the tribunal. Then finally we get on to paragraphs 23 and 24. 23 says, case management, if contrary to the foregoing any stay is ordered, the court should reserve jurisdiction for interim measures and then make various orders for disclosure. Now, in my submission, if a stay is ordered, then the stay is a stay to arbitration, and any further orders are primarily for the tribunal. Of course, there is the possibility of applying for interim relief in support of a DIFC seated arbitration within the DIFC court. But that, again, is not what this claim form is about. And indeed, if you were to stay the arbitration clause, then that wouldn't preclude necessarily such an application. Although, of course, there's no possible basis for any such application. And then finally, paragraph 24 says, orders sought dismiss both applications to strike out or stay, direct the matter to trial, directions to disclosure and accounts and order costs in the respondent's favour. And obviously, as you will anticipate, I would resist all of that. So standing back, Your Honour, we are in a situation where it appears that the claim form itself relates only to the escrow agreement or facts and matters arising out of the escrow agreement, and therefore it is covered by the arbitration clause. The reference to regulatory matters in the skeleton argument, I think, on the basis of that reading, amount only to two categories. The first is an allegation of illegality in relation to performance, i.e. that the escrow agreement should be treated as unenforceable for illegality. That would be a matter for the tribunal. And then the second category is a potential complaint about professional conduct, and that would be a matter for the regulatory authorities governing the conduct of legal professionals within the DIFC. Again, not a matter for a claim form commenced within the DIFC court. So in my respectful submission that in light of your Honour's helpful first two questions, the appropriate order in relation to this matter is for the claim to be stayed to arbitration.
Thank you.
This is Your Honour further. Those are my submissions.
Thank you very much indeed. I'll just check if I did have a note of some queries. I just want to check. I think they've all been dealt with. I think that's it. I think the answer you question, the question you answered right at the beginning, because even if you look at the draft order attached to the second defendant's application, it's on the basis of the strikeout set aside application. But if the court were to find that the arbitration agreement in the escrow agreement warrants a stay of the entire proceedings, then of course that would not be the order in relation to the second defendant. It would be the same form of order as for the first defendant's application.
Yes.
Yes.
Sorry, Your Honour, I've just noticing I've been sent the email that was sent to the court now.
Yes, I'll give you a moment
Thank you.
to have a look at that.
I'm grateful, Your Honour. So the email, as Your Honour indicated, is to the effect that the claimant asks for this hearing to go ahead, and that no doubt was the basis upon which the court did so. It also attaches 2 copies of business licenses in relation to United Arab Law Enforcement League and Legal Consultants FZC LLC in Sharjah, but not, I think, any proof of they are regulated lawyers. They may or may not be, I simply don't know, but they certainly don't seem to be DIFC regulated lawyers. And then there is a reference to somebody having been arrested in Germany, and I can see that there's a document which appears to record the arrest of Turkish gentleman. I don't think it's necessary for me to read out the name. We don't know what that relates to, but it appears to relate to, in the claimant's explanation, a reason why the lawyers can't assist, and he knows he needs to change the lawyers. So that seems to be the email, but as Your Honour said right at the beginning, he asked the court to go ahead, and therefore here we are.
Yes, yes. Is there anything further? I don't have any further questions for you, Mr. Leabeater. I appreciate your assistance. Is there anything else you want to raise before we adjourn?
Nothing further from me. If Your Honour is with us, then obviously we'd be asking for our costs, and there's a statement of costs. I don't know if it would be helpful to have any submissions on that now, or whether that would be appropriate at a later stage.
Out of fairness to the claimant, if the court were to find in favour of the defendant, it would be fair for the claimant to have an opportunity to respond in writing to any order that is made for costs. And I will issue my decision shortly, but I will go away and think about it and finalise it.
Thank you very much. Yes, I was noting before that, unlike in England, the DISC court does have the power to order that immediate assessment of costs be determined at a further hearing before a judge at a later stage, which is a useful.
Yes, actually, the way it usually happens is it's done in writing.
Right, very good. Yeah.
Again, just to save the parties and the court's resources, it tends to be done in writing, and the submissions tend to be very short with very limited pages allowed. Again, just to keep things cost efficient.
I'm grateful.
Well, thank you very much to everyone. And as I say, the decision should be received from the court shortly.
Thank you very much.
Thank you.